and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape.
In development, we're often thinking years ahead, sometimes decades, locking in options now for land that won't be built out for a very long time. The law hasn't always been comfortable with that, and in fact there's a long-standing rule designed to stop property being tied up indefinitely, the rule against perpetuities. So where does that leave modern option agreements? Well, in this episode, we're going to be looking at Crest Nicholson Regeneration Ltd and Calvert, and whether the rule of perpetuities is still something developers and landowners need to worry about, or whether the Perpetuities and Accumulations Act of 2009 has changed the game. So I'm going to hand over now to Richard Snape, who's going to make sense of what is a rather vague definition and give us some more background into this particular case. Hello, Richard.
Hello, Lizzie. How are you?
Oh, jinx again. I'm good, thank you. We're here to talk about a new case from the 11th of March that was at the Business and Property Court, to be precise, which is part of the High Court. And it's about something we haven't really covered before in relation to options, and that's the rule against perpetuities. So I guess a good starting point would be for you to explain what that means and what it is.
Yeah, well, that's my old favourite, the rule against perpetuities. Historically, it goes back, I'm doing a bit of history now, to 1682 in a case called the Duke of Norfolk's case, and it's about not being able to tie up land, doing nothing, for long, long periods. And the original common law rule against perpetuity is pretty incomprehensible. It basically says that no interest is good unless it must vest, if at all, within 21 years of the death of a life and being alive at the creation of the interest. Does that make sense?
Yeah.
No, it doesn't. It doesn't at all. It's the most vague. It goes on to talk about things like the fertile octogenarian rule and things like this. And when I was a land law lecturer at university many years ago, I used to discuss the rule against perpetuities, and no one understands it. It's a bit like Palmerston, Schleswig-Holstein affair. Basically there's only three people who understand it. One's dead, one's mad, and the other's me, and I've forgotten it. But anyway, there we go. I mentioned this before to you, Liz. It's the only academic article I wrote when I was a university lecturer. My first year, on the basis they told me if I won't get a renewal of my contract unless I write a article. So I chose the rule against perpetuities because I knew no one would read it, and even if anybody did, they wouldn't understand it. And that was it. But it's been taken over the years. There was a 1964 Perpetuities and Accumulations Act, which for our purposes here says various things. But Section 9 of the Act, subsection 1 of the Act, says the rule against perpetuities won't apply to an option for a tenant to acquire a reversionary interest in the lease, and provided that the option can't be exercised more than 1 year after the end of the lease, and it's for valuable consideration. So with those provisos, it won't apply to options for tenants to create a reversionary interest. And Section 9, subsection 2, basically says that there's an automatic perpetuity period of 21 years. But then there was the 2009 Perpetuities and Accumulations Act that came into force. I remember it well. I was talking about it at the time, April the 6th, 2010, just before the 2010 general election. They decided to bring it into force. And I wanted you to know, Lizzie, that's the thing that settled me in who I was going to vote for. Any parliamentary party who goes down the route of reforming the rule against perpetuities gets my vote. But basically, I want to cut a long story short, it's basically for interest that come into place from the date it came into force, April the 6th, 2010. Section 15 says they'll come within the 2010 Act. And basically, to cut a long story short, when Section 1 limits dramatically when the rule against perpetuities applies generally, and it doesn't apply to options anymore. It's mainly interest behind a will and trusts and the likes. So that's some of the background. But if you fall foul of the rule against perpetuities, your interest is void. And that caused a problem, certainly for agreements before 2010, if you wanted a time period of more than 21 years before the interest, the option might be exercised. If that makes sense.
I know more about it now than I did when you started.
But you didn't know anything at all about it when I started.
Exactly. Well, should we get on to talking about the case in
Okay.
question?
Yeah.
Some of the background facts to it.
It was a place called Homebush Farm near Crawley, somewhere near Crawley, between Crawley and Horsham in West Sussex. And back in September 25th, 2002, Crest Nicholson entered into, several agreements, but they entered into option to purchase the freehold part of this land for 21 years. And the Calverts, Mr. Calvert, the original party, died, and the people who were now sort of on the other side were his executors and family. But they had this an option to buy the freehold, but also an option to enter into a lease of land which didn't form part of the land that was subject to the freehold option. And the lease included a provision whereby there was a right for the leaseholder to acquire the freehold reversion. They basically did that like that to try and avoid the rule against perpetuities. The solicitors had advised them on this, and apparently they'd done it, and I tried it on another couple of sites near Swindon and East Grinstead. Basically, the idea is that if you exercise the freehold option within a year of entering into the lease, then it won't be within the rule against perpetuities. And as long as you sort of enter into the actual option within 21 years, neither will it be against the rule against perpetuities. But the lease was on strange terms. It was going to be on the same terms as, the lease was on strange terms in that it didn't give a right to occupation for the leaseholder. To cut a long story short, there was, in 2010, Crest Nicholson got planning permission for 2,500 houses on this particular land, and more houses at a later date. So they, on September the 19th, 2023, which was 6 days before the 21-year time period, they say of notice exercising the option to enter into the lease. And there were several issues, primarily if there was a lease in the first place, because if it's a lease, it's going to be outside the rule against perpetuity. Section 9, subsection 1 will apply. And the court decided that you might call it a lease, but it's not a lease. They talked about some quite famous cases that I've mentioned in years past. Street and Mountford, 1985 House of Lords case, where the Lord Templeman said that, basically if it's a 5-pronged instrument used for digging and you call it a spade, it's still a fork, which always annoyed me because forks don't have 5 prongs, they have 4, sometimes 3. I did write to him actually, but he didn't hear anything. It ruined my whole law degree, that did. But anyway, you can't just call something a license and make it a license if you've got exclusive possession for a term at a rent, unless it's an exceptional circumstance, it's a lease. And there was no exclusive possession. You can't have a lease where you can't have a right to occupy the premises. There are other cases that said pretty much the same thing. It's a sham or a pretense. Antoniades and Villiers from 1990, I remember House of Lords case, said pretty much the same thing. And various other, we've done a few years back now, we did podcasts on these guardian schemes, if you remember those, where you put a empty commercial property and you put people who would otherwise be homeless in there to prevent squatters getting in and trespassers and the likes and vandals. And they're a bit of an exceptional circumstance, but usually these things are leases, no matter what you call them, if you've got exclusive possession, but no exclusive possession, no lease. And so it wasn't a lease in the first place. So in the face of it, the rule against perpetuities does apply. But they went on to say the option to acquire the lease was entered into just before the 21-year time period, 6 days beforehand. And so that was valid. And they went on to say the relevant date for deciding whether the option for the leaseholder to purchase the freehold was not when it was first drafted, but it was when it was exercised, and it was exercised after 2010, where the rule against perpetuities doesn't apply to options. So Crest Nicholson won the case. You'll be glad to know.
Indeed. So what's the implications of a case like this?
Well, one thing is, probably doesn't, I think it was a bit of a non-starter in the first place, is that that you can't just call something a license and make it a license, and also that if you haven't got the right to possession of the land, the court talked about Pye and Graham, which I've lost me a little bit, which is about adverse possession and what it means to be in possession. I think that was a bit of a red herring, frankly. But, if you're not got a right to possession, it's not a lease in the first place. You can't have a lease that, without occupation. And also, after that, it's important for developers if they've got pre-2010 options, which they exercise post-2010, because they'll potentially come within the new regime. And there are a lot of them out there. I mean, a lot of these developments are very, very long-term ventures. So it depends on intricate planning permission and the right moment and the likes. So it's quite significant. And it's nice to talk about the rule against perpetuities after all these years.
For old time's sake.
Mm-hmm.
Thank you very much, Richard.
My pleasure, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.